All right, welcome everyone. Rilus Dana here. Today we're talking about another estate planning topic, as always. Today, talking about estate planning for minor children. So, if you have minor kids, meaning kids under the age of 18, not legally adults, what should your estate planning look like? Now, a lot of people start thinking about estate planning once they have kids. That's usually the catalyst for a lot of people. I know for me, it definitely was. Now, even if you have assets, even if you're acquiring assets, if you don't have children or beneficiaries that are important to you, then estate planning usually people don't care about it as much because usually the default works for them. Default meaning if you don't have a last will and testament or any type of planning, it goes to your closest family member. As long as your closest family members are adults, they'll be able to eventually figure it out in court. So today, talking about how to plan for minor kids. There's basically two parts to it, I would say. So if kids are under 18, one of the considerations is who's going to raise them, who's going to physically take care of them and be their guardian. By taking charge and doing your estate planning, you can answer that question. You can choose who you would want to nominate to serve as the guardian of your children. Now, even if you don't have a will, or if you have a will, there has to be a court case to officially appoint someone as the guardian. But if you have a last will and testament naming who you want, the court's going to give a lot of weight to that. As opposed to if there's no planning, then usually a family member comes forward. And if there's no family members willing to take on the minor child, then they go into the state system. So a last will and testament is where you name the guardians of your children. Really easy to do. I have a free one on our website, riluslaw.com. You can go to and do a free last will and testament. Easiest way to do a will is a handwritten one. Arizona and California recognize holographic wills, just means handwritten. So you can download on our website. There's a template to print out where you can write in, you can fill in the material blanks like who you want the guardian of your children to be. Okay, now the other part of planning is for minor children is who's going to manage money for them. So the guardian is who's going to take care of them, who's going to manage money for them. So if you don't have any planning at all, in Arizona they call this person the conservatorship. That's when you manage money on behalf of another and you're appointed by the state. They call that a conservator. Similar to the guardian, requires a court hearing to decide if it's really in that person's best interest to have someone manage their money, and then decide if this person or company is the best fit to be the conservator. These conservatorships have been famous, Britney Spears, and been in the news, kind of bringing light to this subject. But a lot of times it's for minor children. If they have money, who's going to manage it for them? So a trust is a really good tool, even before we get there. So even before we get to a trust, do you have anything to leave behind for your minor kids? I know I felt that pressure as a father. The pressure to care for your kids. Now that still extends after you're gone. If you were to pass away, it's up to you to make sure that your family is protected. So life insurance, I'm a big fan of life insurance in my day job as an attorney, probate attorney specifically. I see it makes a big difference when families do have it. It makes things a lot easier when there is assets to care for things. Otherwise, there can be financial problems right away as well too. If especially if you're the main breadwinner, you're the main one earning income for your family. If you were to pass away, what would happen? So one consideration. Now, if you do have assets and life insurance, who do you name as a beneficiary? Do you name your children? Well, it's good to create wealth, leave things behind for them, but you don't want to leave it to them directly. It's best to have someone manage that for their benefit. Now, a good tool to use is a trust. Today my screen wasn't working, wasn't letting me share my screen right before, so none of my diagrams today, but you can see them on the other videos. Talked a lot about trust, but the basic idea of a trust is it's created by a person. I call the creator the trustor. Sometimes it's called the settlor or the trust maker. They make the trust. It's managed by the trustee, and then the trustee manages it for the benefit of the beneficiary. So I created a trust. I created a trust once I had kids. Now I'm in charge of it. I'm the trustee. The trustee is the manager. I'm also the trustor, which is the boss. So I can make changes to it whenever I want to or need to. And then when I'm gone or incapacitated, it designates who is going to manage things for the benefit of myself if I'm still alive. So that trustee would step in and manage for me if I were incapacitated. And if I were gone, the trustee is going to manage things for my kids. Now, legally, you can give it to your kids at 18. That's the earliest legally. But should you? Maybe not always the best idea. Did you have any friends that got inheritances at a young age? How'd that go? Sometimes it can go well. A lot of times, not so well. So a trust, you can designate at what ages your children receive it. A lot of times what I do in the trust that I design, we'll hold it and we'll say that the trustee can use it for their health, education, maintenance, and support, and then give them an automatic 1/3 of the trust at age 20. And then at age 25, they get half of the trust automatically, and then the balance at age 30. Or we can adjust those ages. But the idea is instead of getting one lump sum, one automatic, one big distribution, you'll hold it back for a while so the trust can pay for expenses for the beneficiary. It can help them go to school and to college, and maintenance and support can be kind of broad. So it all depends on the value of the trust and all of those things on what exactly you can do, but it's up to the trustee to manage it. So best practices, if you have minor children, one, do a will, do a last will and testament, designate who the guardian is going to be, who would be in charge of physically taking care of them. And then if you have any type of assets that you're leaving behind, it's a good idea to consider a trust. Again, a trust is a way to clarify who would manage the things for your children and when they can receive them and what things they can use them for. Hope you found this helpful. Let me know next topics that you'd like to hear about. You can find us at riluslaw.com. Made some new updates to my chatbot there. Go check it out. Go quiz the chatbot there. Very helpful on estate planning, probate, trust administration. They can get you started.